Welcome to a podcast from the 43rd Annual Conference of the National Center for the Study of Collective Bargaining in Higher Education and the Professions at Hunter College. The conference took place on April 3rd, 4th, and 5th of 2016 at the CUNY Graduate Center in New York City.
Good morning. I'm the moderator, which means I introduce them, keep you orderly, and otherwise get out of the way. If you thought about this panel before you came here, you probably thought that you were going to be attending a death watch for the agency fee, if not an actual wake. Events have changed, and a patient has survived and is up and about and may soon be out dancing. Our panel obviously had to change their presentations a little bit under the circumstances, but they are up to the task. I will introduce them very briefly because I don't want to take time away from the discussion. You have their bios with a lot of detail. Our panel consists of Cynthia Estlund, who is a Catherine A. Rein Professor at NYU School of Law. Ruben J. Garcia is the Professor of Law at the William Boyd School of Law, University of Nevada, Las Vegas. And Charlotte Garden teaches at Seattle University School of Law, where she also serves as litigation director at the school's Korematsu Center for Law and Equality. Ruben, you're up first.
Okay, good morning. Thank you so much for being here, and thanks to the organizers of this great conference. As Rick said, we had a bit of challenge reframing our panel after the one-sentence non-decision last week, but we regrouped and we'll do our best to look ahead and stay true to the title, Friedrichs, What Will the Future Bring? I will also start by saying again that I have a couple of posts that I've written on blogs about this case, Hamilton Griffin on Rights, American Constitution Society blog. These are linked to the SCOTUS blog, and they're also in your material today. So, and the post today is actually about the bullet dodged for now in Friedrichs versus California Teachers Association. So that leaves, as Rick said, leaves intact the Ninth Circuit decision upholding California's agency fee statute. And the tensions, though, that we're talking about today, I think, will not go away very easily, or they will continue. Nor, I think, will the misconceptions that the case and its argument, which is, again, the only real evidence that we have that there was going to be a 5-4 decision striking down the agency fee statute, but it did look to be that way in terms of Justice Scalia's leanings. And so these, again, these tensions won't go away, these misconceptions about public sector unions that I don't think exist very much in this particular gathering, but they do exist in the media and in the heat of the public spotlight. So what I'm going to do today is really, again, talk about some history that many of you might know, and some background and some legal background that many of you might already know. But as a way to set up the future, we thought it was a good idea that I talk a little bit about the right to work movement in the history of it and where it stands today. So, as many of you know, the decision in Friedrichs was really about the continuing vitality of the decision, the Supreme Court's 1977 decision in Abood versus Detroit Board of Education. And while that decision is secure for now, we can now return to the ongoing activities of the right to work movement. I personally like to call it the freedom to free ride movement, but that's my personal opinion. But I'll talk about it here in the context of the RTW movement and their decades-long war against the union shop or the agency shop. So I know that, again, most of you are in the public sector, and we've heard, of course, there will be possibly some private sector union organizing in higher education, depending on how the NLRB goes and the recent Duke contract. So the question, again, is what is the model that we're talking about here? What is the model of private sector bargaining that has provided the foundation for the public sector statutes that many of you work under? And again, just for brief explanation, it's basically the idea that representatives, of exclusive representation, that representatives, in the private sector are designated or selected in bargaining units by a majority of employees, and they're the exclusive representatives for the purposes of collective bargaining with respect to working conditions. And so the Wagner model, as you know, tries to increase bargaining power of workers by making the unit as expansive as possible, even to include those who voted against the union, and will still benefit from the terms that it negotiates. So this is, again, the same theory behind the agency fee statutes in the public sector, that they maximize bargaining power and minimize free riding. Non-members in these states are required to pay the cost of collective bargaining and grievance handling. So again, the exclusive representation model exists even in right-to-work states, and such as the one that I come from, Nevada. And so you have, of course, the continual need for unions in those states to try to get people to pay dues instead of the sort of the opt-out model that exists in agency fee states. And so this majoritarian difficulty has resulted in a number of questions or a number of legal accommodations to protect the rights of minority. First, again, I think that some of you might be familiar with the idea of members-only bargaining, and that is something, again, that is a new theory in the private sector that many people are arguing as a step, that should be as a step before exclusive representation, that members-only bargaining or minority bargaining should be allowed. And so there's a large number of scholars who agree with that as possible under the current private sector law. But the same tension, of course, has also resulted in accommodations, as I said, to protect the rights of minorities in an exclusive representation system. So in 1944, the U.S. Supreme Court held that there was a duty of fair representation inherent in exclusivity to prevent racial discrimination, actually, from occurring in railroad unions. In 1956, the court extended that same idea to non-members not being required to support political causes with which they disagreed. And of course, as I said, in 1977, the court extended that reasoning to the public sector in Abood. And then in 1988, in Beck, the court did the same thing in terms of the rest of private sector labor law. So this idea then, in terms of protection of minority rights is central, of course, to the model, or it really helps the model of exclusive representation work. And these accommodations for political causes have basically been used for the purposes of many people who would want to challenge or constitutionalize the right-to-work regime as the reason why they need to sue in other words, to challenge the exclusive representation model. So despite these accommodations, then, right-to-work lawyers have continued historically in their efforts to do what seems to be their ultimate goal, which is a constitutionally mandated right-to-work regime in the public sector. And I would argue, and I think as the subsequent panelists will suggest, that there's certainly an argument they're making for a right-to-work regime in the private sector as well. So to do this, though, the right-to-work lawyers have to expand state action requirements to levels that have not been seen since the civil rights movement of the 1960s. And this is basically by arguing that unions in both the private and public sector use dues for political purposes anyway, and thus requiring dues from people who do not want to join the union is unconstitutional compelled speech. And that, I think, Charlotte will pick up on in the context of Friedrichs and the context of the arguments that were made about the political nature of state bargaining. And again, in the private sector, the argument runs very similar. It's that unions are political entities in the private sector anyway, and therefore anything they do is essentially, that people don't agree with, is essentially compelled association and compelled speech. So in her excellent recent book, The Workplace Constitution from the New Deal to the New Right, Sophia Lee traces the development of this constitutionalization of the workplace on both the right and the left. Again, the early left attempt to try and constitutionalize a right to organize and right to associate, and then she also goes through the left attempt to constitutionalize workplace justice in affirmative action. But our history suggests that after Friedrichs, now the non-decision in Friedrichs, the Right to Work Committee will continue its decades-long constitutional litigation movement to challenge what seems to be Congress's, the model, in other words, Congress's choice, which is exclusive bargaining of all workers in legally defined workplaces best serves the economic interests of the workers and their employers. And I think that you look at the briefs in Friedrichs, you see that. Many of you perhaps were involved in some of the briefs on the employer side, also suggesting that agency bargaining actually benefits both the employees and the employer. So again, what it seems to be is really at work here is an attempt to suggest that there's something unconstitutional about, in the end, about exclusive representation. And I think there are several suits that are arguing that, including one that in the Fifth Circuit called Cerna versus Transport Workers Union, which will challenge agency fees under the Railway Labor Act as unconstitutional. But all of this, of course, as you know, as Bill mentioned, really rides on that ninth justice, who that ninth justice is. And so these challenges will continue. They'll continue to percolate in the lower courts. And much like they did before Friedrichs, they will wait until the Supreme Court seems favorable to, 5 members of the Supreme Court seem favorable to striking down, again, Abood, and then going from there in terms of other, possibly long-shot attempts to constitutionalize the right workplace in the private sector, but again, that seems to be their ultimate goal. So the real bullet then, in terms of the that was dodged by the labor movement in Friedrichs, really seems to go to questions that were already invited by the court's 2014 decision, Harris versus Quinn, which held that agency fees are unconstitutional for so-called partial public employees, such as home health care workers, and struck down, that case struck down the attempt by the state of Illinois to give a modicum of collective bargaining through the state rather than individually with people whom they provide service for in their homes. So again, as I said, the composition of the Supreme Court will determine whether this invitation will be followed up on in a later case. So if any of these cases do eventually become successful in bringing the issue to the Supreme Court, as Professor Lee discusses in her book, we will again see the employer community and, as she says, the New Right Coalition divided in somewhat. The question would be whether the business community would really want to see the end of exclusive representation, in other words, the end of one bargaining representative, and would they rather see pluralistic members-only bargaining, or would rather continue to impose unions in the current exclusive representation system. And again, I don't think that they do. I'm sure that most of you here probably don't favor kind of a system where you have many unions representing many different minority constituencies. But again, that is the logical conclusion of the constitutionalization of the workplace by the right and the right to work movement. And so again, they're at the same time, interestingly, of course, we have labor's constitutional vision as well, not just seeing, of course, the possibility of new arguments in terms of freedom of association or the right to bargain, which actually could have been a byproduct of Friedrichs. But in the end, the dilemma being, would some minority representation be better than no representation in some cases for labor? So in the end, again, I think that these questions or these tensions will continue to percolate in the lower courts, but they don't have a realistic shot of getting to the Supreme Court until we know who that ninth justice is, or until there's a ninth justice maybe 4 or 8 years from now that is more favorable to the right to work movement. So Friedrichs, again, may be part of the right to work's constitutional strategy, but as I think Cindy will discuss, there may be counter strategies from labor's side as well that will also destabilize, or rather add to some new ideas for labor's side as well. So the future, again, of collective bargaining will likely be more energy spent in litigation, unfortunately, rather than trying to work at solutions that are at the bargaining table that I know that you're all involved in. So with that, I'll close and thank you very much.
Hello. There we go. So I'm delighted to be here, looking forward to meeting at least some of you during the rest of the conference. So given that Friedrichs ended up as a bit of a non-decision, I'm going to focus today on First Amendment challenges to different aspects of union representation that are now percolating up through the federal courts and the circuit courts, or the federal district and circuit courts. So as you'll see, those cases are remarkable for their breadth and ambition. If successful, they'd be much more damaging to unions in the public sector than Friedrichs would have been. And that's because they're not limited to union fee structures. Some of these cases attack the American model of union representation in a much more fundamental way, and would therefore alter public sector jurisdictions' calculus about whether public sector bargaining should be permitted at all. So I'm going to talk just briefly about why these cases are coming now, focusing a bit on the outsized role that Justice Scalia had played, given that it now seems like an appropriate time to reflect on Justice Scalia's role on the court, and then talk some about what these new cases are, where they are, and where they might be going. So first, the road to Knox, Harris, Friedrichs, and beyond. So why are these cases bubbling up now? So Justice Scalia looms large on that road, and he looms large on the road to the coming cases. And that's because he's really sort of posted the key signpost to really kind of torture this metaphor about the road over the last couple decades. And then as the swing justice, he was also the ultimate gatekeeper. So on one hand, Justice Scalia had defended the constitutionality of union fees and the Abood decision specifically. He was also always very skeptical of public employees' First Amendment rights, a great defender of the idea that private workplaces and public workplaces should be roughly equivalent in terms of employers' ability to control employees. On the other hand, though, he was also a significant part of the reason that it began to seem like an opportune time to bring cases challenging agency fees. So in 2007, he wrote that it's undeniably unusual, right, undeniably unusual, for a government agency to give a private entity the power, in essence, to tax government employees. So quite a different tune than he sang in earlier decades when he defended the Abood decision and the idea of public sector agency fees. And then, of course, that language, right, that undeniably unusual tax language, figured prominently in the very first lines of the petitioner's briefing in Knox, right, really setting the stage. But then two other justices bear specific mention as well, right, two justices who are still in the court. First, there's Justice Kennedy, who's been described as the foremost defender of free speech principles on the modern court. He's earned that description in part because he authored decisions like Citizens United v. Federal Election Commission. Okay, so why am I mentioning a campaign finance case while talking about union agency fees? Well, Citizens United, as many of you know, freed unions like corporations to spend general treasury funds on more types of election-related independent spending, and therefore, conversely, right, heightened incentives to limit union participation in politics by folks who are more likely to be on the Republican side. So, for example, an employee of the Freedom Foundation, which operates up in the Pacific Northwest, has brought some of the pending suits I'll be talking about in a minute, characterized the foundation's work as, and I quote, "Our number one stated focus is to defund the political left," right? They're doing that by trying to limit union revenue. And then there's Justice Alito, who practically invited Harris and Friedrichs in his opinion in Knox. He wrote both Knox and Harris. And his opinions laid the groundwork and provided immensely helpful language to the lawyers who were bringing those cases. In particular, in Harris, the decision really did three things that are at the core of the new arguments I'm about to talk about. So first, it held that there's such a thing as a partial public employee, somebody whose terms of employment are set jointly by a government entity and a private customer. By Harris's logic, these folks are neither fish nor fowl. They're not pure public employees. They have some kind of enhanced First Amendment rights, and that reasoning allows courts to sort of free themselves from established precedent with respect to these employees. Second, Harris emphasized that collective bargaining in the public sector is more political than bargaining in the private sector because contract terms touch on issues of public importance, and really elevated that concern in the opinion. And then third, it suggested that public sector unions and employers ought to have to prove empirically that their fee structures are necessary to the integrity of the bargaining relationship. And any of you who work doing that kind of empirical research know how difficult it is to prove those relationships at the kind of level of certainty that the courts seem to be looking for. So taken together, these themes form the basis of this new generation of challenges to public sector union structures. So here are the new cases. I've tried to kind of roughly divide them into categories. The categories, I will tell you, have been proliferating over the last year or so. Okay, so first, a set of cases that are simply about enforcing Harris. So there was some confusion after Harris about how broadly the decision would apply. That doubt has mostly been resolved, almost entirely been resolved in terms of applying Harris, especially to home care and child care workers who qualify as partial public employees. What remains, though, is litigation about whether union-represented non-members can get fees back that they paid to their union representative before Harris v. Quinn came down. That issue and how it's litigated, in particular whether it's litigated as a class action or on an individual basis, is hugely important. So, for example, in the Harris case itself, the National Right to Work Foundation is now attempting to represent a class of 80,000 home care workers, all the home care workers represented by SEIU Healthcare, Indiana and Illinois, who paid an agency fee without joining the union since April 2008. That number comes to more than $30 million. The union's response is that it's not appropriate to assume, right, that every represented non-member actually would have objected to paying the agency fee. And so it's not appropriate to treat those 80,000 home care workers as kind of an undifferentiated class. The motion for class certification is pending in a district court in Chicago now. The fight about whether agency fee payers should be treated as kind of a monolith has arisen in other contexts, and unions have often been successful in defeating class certification, but that's definitely one to watch. Okay. Second, a set of cases that are attempting to make it easier to be a union objector, right, to opt out of paying non-mandatory dues or fees. Many of these cases ask courts to expand on Knox, right, to hold that unions need affirmative consent to charge non-mandatory fees from non-members. But they also seek enhanced protections in terms of longer opt-out windows, the right to opt out at any time rather than during a specific month, to opt out just once and have that opt-out carry over from year to year. Some of these cases are succeeding, sometimes without the union really fighting the issue. Okay. Third, a set of cases arguing that mandatory union fees are unconstitutional in the public sector. My saying that might have given you a sense of deja vu. That was exactly the issue in Friedrichs. A number of cases are waiting in the wings to make the same argument. So expect those cases to be in a bit of a holding pattern for now, and to possibly see new life once we have a ninth justice, depending, of course, on who that is. Okay, so now we get to kind of the really interesting cases. So a set of cases argue, and Ruben mentioned these, that exclusive representation is unconstitutional as to partial public employees. A set of cases make this argument around the country. So far, none of them have been successful, and I think that's appropriate. I think this theory is a bit quixotic. So for one thing, and there are a couple reasons for that, but one is that the plaintiffs floated this argument in Harris before the Supreme Court. Several members of the court seemed distinctly skeptical of it, although the justice on the right who was most skeptical of this argument was Justice Scalia. In fact, Justice Alito sort of rushed in during argument to do a bit of a rescue mission when the plaintiff's lawyer was being pressed on whether or not he was really arguing that exclusive representation is unconstitutional, right? Some justices seemed quite incredulous. And Justice Alito sort of pressed him to clarify, well, you don't really need to win on that issue, right? You can still win on the agency fee issue, even if we disagree with you as to exclusive representation. Then the other reason I'm skeptical of this argument is the plaintiffs will have to deal with a Supreme Court case called Minnesota v. Knight, which upheld Minnesota's exclusive representation rule against a group of traditional public employees' arguments that they should have the same rights as an elected union to meet and confer with their employer. In the new cases, right, in these cases involving partial public employees, the plaintiffs argue that Knight is distinguishable for a couple of reasons. Most significantly that as partial public employees, these home care workers and child care workers are not trying to seek bargaining rights of their own, right? They're just seeking to displace the union as their representative. Right? In other words, they're essentially arguing that they have a constitutional right to have their terms and conditions of employment set unilaterally by their employer. So it seems to me that the plaintiffs will have a difficult job establishing that as a constitutional principle, and that Knight can exist alongside an argument that there's a constitutional right against exclusive representation as to any type of employee, right, partial or not. Also, that holding would lead to what I think of as a somewhat odd result, possibly counterintuitive, that government employers should be free to consult with organizations or entities about workers' employment conditions, right, consultants, et cetera, except when the organization owes a duty, right, to the represented workers involved. Okay. Fifth, there are a couple of cases aimed at limiting how unions persuade workers to become members. So these cases really go hand in hand with cases like Friedrichs. Okay, so first, a group of California teachers are challenging the California Teachers Association's somewhat unsurprising rule that members must join the union and pay dues in order to get membership benefits and participate in union democracy. Case is pending at the district court level now. The district court has already held that the Constitution doesn't apply to the relationship between unions and represented workers, at least not without proving some substantial state involvement in that relationship. But the plaintiffs have filed an amended complaint, and so expect to see more in that case. And then closely related, a case just filed in my home state in Washington. The plaintiffs are challenging a rule that gives the union the opportunity to talk about its role during new hire orientation for home care workers. It's a rule that some states adopted after Harris, right, that some states were considering as a potential response to Friedrichs. I'm only aware of the Washington suit so far, but I wouldn't be surprised if there were more coming, given that other states have similar processes. And again, the plaintiff's legal theory depends on this distinction between partial and full public employees, right, asking the court to take the Harris decision and make a sort of further leap from it. And then finally, at least one case argues that private sector union relationships also implicate the First Amendment. In that case, the plaintiffs asked the court to extend Knox and Harris into the private sector context based on some earlier case law that suggests that in the Railway Labor Act context, though not necessarily in the NLRA context, union security implicates the First Amendment. So that case has been in a holding pattern awaiting Friedrichs as well. So far, the plaintiffs had been successful at achieving class certification, right, treating all the affected workers together, but not in their actual legal theory, right? So the court had granted summary judgment. That's now going to be up on appeal in the Fifth Circuit. Okay, so what to make of these cases? So first, they've been largely unsuccessful so far, with the exception of some of the cases that would sort of tinker with opt-out procedures and some of the cases that just sought to apply Harris. I wouldn't expect that to change. These cases were being queued up for a Supreme Court with 5 conservative members who are willing to discard precedent and establish much broader public sector employee speech rights in the context of union representation. I revised the right to amend that opinion in the event that President Trump, right, or any other Republican president is able to appoint somebody like former Solicitor General Paul Clement to the court, right? Then all bets are off. Second, the breadth of the pending cases show what's at stake, right? They attack every aspect of public sector union representation, at least as to partial public employees. But the path from Harris to Friedrichs suggests that the partial public employee cases are the thin end of the wedge, right? They are just teeing up the next round of cases that would involve traditional public employees and eventually maybe even private employees. Third, these cases should be viewed alongside other significant cases that use the First Amendment as a deregulatory tool. And you've probably read about some of these cases in the election context, the consumer context, the workplace context. I can talk about some more of those during the Q&A, but these challenges to public sector union representation really snap in with a sort of broader First Amendment deregulatory theory. Okay. Thank you.
Good morning, everybody. The logic of my coming last is I'm going to move from defending against the onslaught of attacks against unions and collective bargaining toward a more offensive strategy, but it'll take me a few minutes to get there. So labor unions offer working people, as we know, a vehicle to aggregate and amplify their voices both at work through collective bargaining and in the political process. So unions have two sides. Let's call them the associational side and the regulatory side. So unions are self-governing membership associations that exercise their members' rights, including through politics. And they are also, under our system of labor law, the exclusive representatives of employees within the statutory structure of collective bargaining. So, as we all know, in the US, a union chosen by a majority in an appropriate bargaining unit represents all employees in that unit, and by judicial interpretation has a duty to fairly represent all those members. That's very, very different from any other kind of voluntary membership association. So the battle against mandatory agency fees, both in litigation and in politics, attacks both sides of unions. Clearly, it's a deliberate attack on the funding base of unions as political actors in a very hyperpolarized political climate. But it's also part of a larger assault, and Charlotte alluded to this at the end, a larger assault on institutions of collective self-governance that includes unions but is not limited to unions. And it is based partly on this burgeoning First Amendment right to opt out of collective decisions made through democratic processes. But the legal attack on unions and agency fees is clearly grounded in the regulatory side of unions, the regulatory face of unions. So labor laws in both the public sector and the private sector put unions at the heart of public regulatory structures for governance of labor relations. Labor law confers very unusual benefits, privileges, powers on unions as compared to other voluntary associations, as well as some unusual burdens or duties or restrictions as compared to voluntary membership associations. So the regulatory structures of labor law, and especially the unusual powers of unions to bind non-union members, open the door to these constitutional claims that we've been hearing about against those unusual powers. So in other words, those legal attacks would have no traction against purely voluntary unions that exercise no statutory powers of exclusive representation. And maybe that's where we're heading, possible, we've heard a bit about that. But those regulatory structures and the principle of exclusivity in particular, as long as they exist, and so far have also limited the reach of the constitutional attacks on unions and the agency fee structure. So the cases that we heard about already, Street, Abood, Beck, the cases that draw this line between unions' political activities and unions' collective bargaining activities, they sharply distinguish between those two sides of unions. Unions as political ideological actors, acting on behalf of their members as they have a right to do, and unions as regulatory actors in a system of collective bargaining set up by statute. So unions are permitted, again, under the law as it exists now, to collect or seek through collective bargaining mandatory fees to support their collective bargaining functions, but not their political ideological functions. So the principle of exclusivity gave rise, Charlotte just talked about this, and I think Ruben did also, gave rise to the notion of a duty of fair representation of all members in the unit. Duty of fair representation plus exclusivity is what justifies the fair share agency fee. So as to the costs of collective bargaining and representation, the mandatory fee is necessary to avoid these very corrosive free rider problems. But as to the cost of politicking, that justification doesn't hold, according to the court, especially given the greater intrusion on the First Amendment interests of non-union members, in not being corralled into supporting ideological activities they disagree with. Now, I think, many of us think, that these cases reflect an inflated view of the First Amendment interests that are really at stake in union fees. And a very stingy conception of workers' shared interests in the political process. But there is a deep logic to that line that the court has drawn, and that's in contention now with cases like Friedrichs. And that logic reflects the basic, what I've called quid pro quo, that's established by our American model of bargaining, with extraordinary privileges and benefits of unions on the one hand that are offset and justified by some extraordinary duties, burdens, and restrictions, and vice versa. So that logic is replicated in many state public sector labor laws. That logic, that system is very much under attack, a long-term attack, but as long as it exists, that's a logic that should be on the minds of the courts when they're thinking about these challenges. So Friedrichs had sought, and the right to work movement will continue to seek to challenge that logic with regard to agency fees, and in doing that, to unsettle the foundations of our system of collective bargaining. So a few things are now clear after last week's summary affirmance. Abood remains good law for now with regard to ordinary public employees. So in those states that do allow the fair share agency fee, unions will not immediately be faced with the bleeding of money and members that can be triggered by allowing objectors to free ride. Second, of course, the next Supreme Court appointee will decide the fate of Abood in the public sector and eventually perhaps in the private sector. It's also certain, though, that the right to work movement will not give up their fight. In particular, and going forward even before that vacancy is filled, the movement will continue its campaign to abolish agency fees one state at a time through politics, by passing right-to-work laws or strengthening existing right-to-work laws. Right-to-work laws exist now in over half the states. So what the right-to-work lawyers have sought to do in the public sector nationwide through Friedrichs, and what they will eventually continue to try to do, through constitutional litigation, states are allowed to do through not only in their own public sector labor law, but in the private sector. That is to abolish mandatory fair share agency fees. That is to create, states are allowed to create a free rider problem that destabilizes the foundations of an exclusivity-based collective bargaining system. So the battle against state right-to-work laws is being fought, has to be fought in the political sphere. But in a post-Scalia world, unions and their allies should be thinking about affirmative litigation strategies that turn the tables on the right-to-work movement's 70-plus year constitutional litigation campaign against mandatory union fees. So I want to focus first on the private sector, and I want to issue a little bit of an apology, or at least a warning to the non-lawyers in the audience, because things start getting a little technical at some point. So for reasons we've all noted, right-to-work laws that ban the agency fee agreement corrode, undermine, destabilize the foundations of the system that Congress established for private sector labor relations across the whole country. They impede unions' ability to solve the the collective action or free rider problems that are created by that are created in an exclusivity system. So those laws would clearly be preempted by the National Labor Relations Act, but for one provision of that act, 14B, enacted as part of the Taft-Hartley Act in 1947, which expressly allows states to restrict union security agreements. And on the conventional reading of that provision, it allows states to undercut the logic and integrity of the federal system by banning all mandatory union fees that support those exclusive collective bargaining activities. So the question is whether that conventional reading of 14B is correct. Its tension with the logic and integrity of the collective bargaining system is the first and most important reason for doubting that that conventional reading is correct. Of course, logic doesn't have to govern in Congress. Congress can illogically carve out exceptions as part of the statutory sausage making that we all know about. But did it do that? Did it do that clearly? Consider the text of Section 14B. It allows states to prohibit, quote, agreements requiring membership in a labor organization as a condition of employment. That pretty clearly includes, under Supreme Court precedent, agreements requiring payment of full dues. In other words, agreements to pay the financial equivalent of membership. That is basically the only kind of fee agreement or union security agreement that the statute now permits at all, or even in 1947. The statute permits agreements that require employees to tender the periodic dues and fees uniformly required as a condition of membership. So it does make sense to construe that 14B states can opt out provision to permit them to bar agreements requiring either union membership or its full financial equivalent. But what about agreements that require only a partial agency fee? Under the existing Supreme Court precedent in the Beck case, that's all unions can now get under the National Labor Relations Act. Public sector, private sector, they can only get the partial core agency fee. Still, it doesn't make sense to construe that language I read earlier from 14B to permit states to prohibit partial agency fee agreements, and no Supreme Court decision has held that it does. It's contrary to the language of the statute. That is not an agreement requiring membership by any stretch of the imagination. And it's contrary to the logic of the statute, which is undermined by the free rider problem. So on that reading, 14B does not save state laws that bar all union fees, including the fair share fee. In other words, those broader state right-to-work laws would all be preempted by federal law in the private sector. That is not my original crackpot reading of Section 14B. That is the reading of Judge Diane Wood of the Seventh Circuit, an extraordinarily talented, smart judge, in her dissent, yes, from a panel decision upholding Indiana's right-to-work law against a preemption challenge. That case was based on, if you're a labor lawyer, I recommend it to you. It's based on an exhaustive, dense analysis of the statute, its history, and all the precedents. It's also been foreshadowed. And by the way, half the Seventh Circuit on an en banc petition agreed with Judge Wood. So this argument may have legs. Now, so the basic idea behind this argument is that the Beck decision in the 1990s stripped down what the statute permitted to the core, that Congress, that it did all the work across the whole country that Congress intended to permit states to do, that is, to strip down agency fees that go beyond the core collective bargaining functions. One might object, if one is a lawyer, that this reading of 14B would render that 14B provision is superfluous. It wouldn't do any work anymore. It would only permit states to do what has already been done by the court under the First Amendment or under a shadow of the First Amendment. But that's a product of the fact that Beck itself gave an egregiously implausible interpretation of what the statute actually allowed. So I realize I'm gonna start getting way too technical if I continue on this. The point is, on this very plausible, learned reading of the National Labor Relations Act, broader state right-to-work laws that prohibit mandatory fair share agency fees would be preempted. So now that's a strategy that people should start thinking about, and it is the basis for a current union lawsuit against Idaho's right-to-work statute. The consequence would be to remove all effect from right-to-work laws in the private sector, strip them back to the limits that are imposed according to Supreme Court precedent by the National Labor Relations Act itself. That would bring us back into some logic and integrity to the collective bargaining system, would not allow states to undermine that system. So Congress could overrule a decision along these lines and could say, no, we meant to allow the states to prohibit all union fees. They could do that. Congress has had a lot of trouble in the last 60, 70 years amending the National Labor Relations Act. So, but that is a qualifier of how durable this strategy is. Now, this argument so far is entirely about the National Labor Relations Act and private sector, federal preemption in the private sector, but there's another part of Judge Wood's dissent that potentially extends to the public sector. So Judge Wood said, one of the reasons to buy this reading of the statute is that right-to-work laws that bar fair share fees work an unconstitutional taking of the union's property. In other words, there's a constitutional problem with forcing unions to spend their money and their members' money to serve non-dues paying non-members. So for Wood, that takings argument is another reason it casts a shadow and should lead to what the courts call constitutional avoidance. Let's construe the statute so that it doesn't raise that constitutional takings problem. But consider right-to-work laws in states with public sector bargaining regimes that are based on exclusivity, majority rule, duty of fair representation, et cetera. That same takings argument clearly would apply. If the state law is forcing the right-to-work ban on core agency fees, is forcing unions to fork over their members' dues to pay for services of non-fee paying members, that would be an unconstitutional takings. That just is to suggest some of one possible affirmative litigation strategy. The First Amendment and the Constitution has not been the friend of working people, progressives in a lot of cases recently. But maybe in a post-Scalia court, not a Trump court, but in some future world, the Constitution could again become the friend of working people and unions in this respect at least. Thank you.
It's good to end on a note of encouragement. We have lots of time for questions, and I think I'm going to use my moderator's prerogative to ask the first one. So, as you heard before, I'm the General Counsel of CUNY, so I don't have to spend a lot of time thinking about this issue. We're a fully unionized university in a state that has no right-to-work law, and so I have other First Amendment issues that I need to concern myself with. This isn't one of them. But one of the ones that I do have to be concerned about are claims by employees of retaliation for the exercise of their First Amendment rights. And under the case law relating to public employees, which all CUNY faculty and staff are, there is a distinction between speech as a citizen on issues of public concern, which is protected by the First Amendment, and speech on private matters such as employment issues, which is not protected by the First Amendment. So could someone explain to me why, if that's the law on public employee free speech rights, why it's a First Amendment issue that would prevent agency fees to compel public employees to contribute to the work of unions strictly on matters of collective bargaining? I don't get it.
I'll just start. And then, that's one of at least 4 tricky moves that a conservative majority would have had to make in holding for the plaintiffs in Friedrichs. Stare decisis, of course, they would have had to overcome stare decisis. Federalism, leaving the states to resolve their own public employee collective bargaining as they wish. Separation of powers, messing with what the legislature decided was the right answer. And then this is the 4th reason. There's a conflict between, but it's a funny conflict. So Justice Kagan in the Harris case had to switch sides as well to argue precisely, given that precedent, that bread and butter collective bargaining issues are not matters of public concern. That's a reason for upholding the agency fee. I cringe when I read that, because we've been on the other side. I've written on the other side. I think some of us have, others of us have written on the other side of that. So let me hand it over.
Yeah, I mean, so when I talked about Justice Kennedy being the foremost defender of free speech on the court, there should be a little asterisk, right? Does not apply to public sector employees, because he's also written some of the important decisions that I know that Professor Herbert has talked about, as in some of his writing, that really limit public sector employees' free speech rights. So Justice Alito's move to get around that distinction in Harris was interesting, right? He said, well, it's not a matter of public concern if you, a single public employee, go into your boss's office and say, I want a raise. But if you get together with 80,000 of your closest friends and say, we all want a raise, then that becomes a matter of public concern because the public fist can be implemented, or can be implicated. So that's the line that the petitioner's attorneys were treading in Harris. I think it's a thin line, but that's the line they were pursuing. There was another public employee speech case called Heffernan before the court this term, and that case and Friedrichs were argued something like a week apart from each other. And I would sort of encourage folks who are interested in this issue to go back and read those 2 transcripts side by side. Because in Heffernan, and I can tell you just a little bit about it, right? So in Heffernan, a police officer was fired for his perceived support for a mayoral candidate in New Jersey. He was not actually a supporter of that candidate, as it turns out. He was just getting a sign for his mother. So he's like being a good son, right? He's getting the sign. He's seen with the sign, and he's fired. He says, well, the First Amendment should be there for me whether or not I am actually in my heart expressing political support for a candidate. It should be there for me even if I'm just wrongly perceived to be supporting a candidate. The conservative justices completely skeptical of his claim, the liberal justices fairly supportive of his claim, the polar opposite from the positions the justices were taking in Friedrichs. Now, some of the justices have sort of said, look, I don't love the Supreme Court's other public employee speech cases, but given what they are, we conclude that there should not be a separate rule that applies just to unions. But not all of the justices have even sort of gone that far to reconcile that tension. So yeah, I agree that is a huge challenge.
I'm just saying one more thing. Oh, sorry. One more thing to Rick's specific question. The upshot of this distinction between, well, there's the individual versus there's the 80,000, is that firing a public employee for saying what they think is not, in the conservative majority's view, a First Amendment problem, but forcing them to pay a small fee, usually a fee that is outweighed by the economic benefits of the agreement that they are getting, is in exchange for that fee. That's a First Amendment problem.
Right, and I would just, I would just add that this was one of the constitutional anomalies that, and again, I think Cynthia's written in terms of unions being kind of a constitutional anomaly compared to the rest of public employee cases. And again, that was one of the silver linings that we were talking about or thinking about, maybe out of the Friedrichs decision. I guess we'll have to wait another day for the court to sidestep that silver lining or find a way out of that potential silver lining for employees.
Okay, let me open it up to other questions. I see a microphone over there and a microphone here, and if you make your way down to the microphone, I'll call on you. Given the composition of this audience, I'll start with the first speaker to the left.
No, I'm on my right, so. Aaron Nissenson, AAUP. I was just wondering, we worked on the Friedrichs case and also the Fisher case, which had oral argument. And it seems to me one of the underlying themes is this excessive individualism, in the sense that if one individual is hurt a little bit by collective action, we have to overturn the collective action, you know, in fealty to the rights of the individual. And that it's not just a union issue, it's a issue in affirmative action and in other collective action cases and situations. Now, unions being the most prominent, but my guess is that there are other ones out there. And there is a logic to that. I mean, there is a logic to that notion that you cannot have one individual burdened at all, or else we throw out the system. I don't know if you've thought about that or thought about it as part of this broader context of individual rights versus collective action, which seems to be the big theme in these cases.
And again, I think this was one of the tensions that we saw in the argument coming out, where Justice, I think it was Justice Alito, who was basically saying, you know, that the difference here is that we have many potential people who are, you know, harmed by this unconstitutional action, right? And again, I think this also raises you raised the affirmative action cases, and again, I would commend you, Sophia Lee's book, which also goes into this, you know, sort of constitutionalization of harm, I guess, by affirmative action that was also part of this movement. So again, I think that you're basically hitting upon the tension that in many ways, you know, the court has tried to deal with since, you know, the 1940s, since this model was created, right? And to many of us, really worked out a pretty good, several different good accommodations, and I think the response has been, or the campaign really has been, to really even, you know, go against those accommodations. So and I'm sure Charlotte has seen these arguments that the duty of fair representation doesn't really exist. You know, that unions take it willingly. You know, all these things that you sort of see on the internet, where everything is true, of course. It is just, again, as I've argued anyway, it's been a sort of a campaign of sort of misconceptions about how things actually work. And again, I'm glad we have people here who kind of know how things actually work to kind of try to deal with those misconceptions.
Yeah, I mean, so I think if you look at Supreme Court approaches in the kind of 70s and 80s to problems like free speech, like affirmative action, like other constitutional questions, the court was willing to engage in kind of balancing, right? What are the relevant interests and burdens? How should those shake out? And that's really how Abood worked, for example. The court said, okay, we recognize that public employees who object to union positions have an interest that's legitimate. We do. We also recognize the collective interest, and we sort of throw those into a pot together, and we come out with the Abood rule. And, you know, maybe it's not the most precise way of formulating an approach to the question, but it's one that basically works, that comes out with some reasonable sort of guiding principles. And the Roberts Court is really eschewing that approach, and instead favoring kind of in many contexts, but especially the First Amendment, an approach that heightens the level of scrutiny that courts apply and say, you know, if you can't prove that, to go back to the union example, if you can't prove that this is the only way to manage your public sector employee relations, then you can't intrude on the rights of individual dissenters. But that's not, you know, that's the approach taken not only in union cases, but also, you know, campaign finance, right, in Citizens United. The court said, you know, previously we've allowed for a kind of broader scope weighing of competing interests. Right now, we're not going to do that.
So just in case you hadn't sort of cast a broad enough net with your question, I think that this notion of excessive individualism and sort of undermining collective decisions extends to individual claims to opt out of statutory schemes. So the Affordable Care Act has been the subject of a barrage of attacks of individual employers trying to opt out. And we've seen now for more than, well, really going back from the beginning of anti-discrimination law, this assertion of a right to opt out of anti-discrimination law protection. So I think it is a very, very large move, and especially to the extent that the First Amendment has become the main vehicle for these challenges. It's part of what I mean when I say the First Amendment has not been our friend lately, that individual right to opt out. Of course, the First Amendment and much of the Constitution is meant to protect individuals against overreaching by majorities, but the overreaching is all on the other side, I think, lately.
I'm going to like to stay with this topic just a little bit longer because it's an awfully interesting one and because there's nobody standing at that microphone at the moment. So if you ask a bunch of lawyers a very broad question, you tend to get a lawyer's response. So I'm going to force the people on this panel to expand their thinking a little bit on this question. Excessive individualism or even libertarianism isn't exclusively within the realm of court decisions in the First Amendment. It's been the dominant theory in political theory for much of the last generation. There have been a few communitarian political theorists, but with the exception of Michael Sandel, who's a very gentle communitarian, they don't get a lot of play. We see it in the society in which we live, where people seem to be more isolated and unconnected with each other. Bowling alone is sort of the sociological exhibit A on this. We see it in many areas. Now we see a group of people who have been left out coming together supporting Donald Trump, not exactly the most positive way of using this dissatisfaction. I was wondering if we could get you guys to comment a little bit about what's happening around this country, in its society, politics, political theory, that underlies the direction that this Supreme Court has been moving in.
So there was that famous, I think it's real, sign back in 2008 at an anti-Obama sign saying, "Government, get your hands off my Social Security." There is a disconnect. I think, if you focus people's attention on the extent to which they depend on and want government programs that help support a decent measure of security, not as much as some of us might like, they don't want to dismantle those programs. But there is this, you're right, this ideology of, leave us alone, government is the problem. And the extent to which that's gotten whipped up and exaggerated and become the focus of the Republican base is kind of a scary prospect. But we're not cultural theorists up here.
But what about unions? Why haven't they been more successful in countering that?
Well, I think one challenge that certainly the communications challenge has been real, right, and continues to be real for unions. I'll say that I teach labor law in Washington State. We have, as you know, quite, pretty high union density, among the top 5 in the country. It's still unusual for my labor law students to have a background either in a unionized workplace themselves or have a family member who has been in a union. And so what they know about unions is often what they have heard in the media, and that is, teachers' unions harm our children, police unions harm our communities, and they are not hearing, I don't think, they're not hearing a strong response to that message. I mean, that's a bit of an anecdotal response, but.
Well, for another anecdote, I was at a discussion this week, a conversation about labor issues with an undergraduate audience at NYU, and there were some people who did get it.
I think it's an environment, basically, as you pointed out, Rick, basically of this sort of anti-elite, sort of social and cultural alienation, that I think lends to the rise of certain presidential candidates. But again, I think also, as I said before, the Lee book really talks about sort of not just the litigation campaign, but also sort of the communications campaign that I think is really going to this conclusion, or at least they're trying to push the conclusion that all unions are political. In fact, when you look at their materials, they basically say everything the union does is political, even in the private sector. This is so that line that Cindy was talking about, that they're really trying to blur between association and political activity. They've done so successfully, and so people think of, and perhaps for various reasons, people think of unions as political actors mostly, rather than sort of associations or representatives. So that's part of the communications challenge as well, I think.
Thank you. Question from over here.
Thank you. I don't think I need the mic. I might blow you out if I use it. I'd like to start with a quick response to that, and then I have a question. My name is Carl Levine. I'm an attorney on the labor side at Levy-Ratner, where I represent primarily academic unions. My sense is that notwithstanding the fact that the law is currently stacked against organized labor, that there has been incremental growth. And part of that, I think, is because it's seen as a political actor sometimes, and people want that, as well as the fact that there's a perception that people with unions, which I think is accurate, do better. But also, anecdotally, the people who we see applying to work with us on the labor side, we get a higher level right now of applicants. We're seeing a lot of people from Ivy League law schools and elsewhere who are committed to social justice, who want to work in support of the labor movement in a way that 10 years ago we didn't see as many people. Okay, I'd like to piggyback on the question you asked, Mr. Schaffer, at the very beginning. Because we've gone a little further afield and it's an issue I'm facing, and any advice you can give me concerning what I tell a union president who wants to speak before the board of trustees of their institution and who, following my advice, says, I'm here speaking as a public citizen on a matter of public concern to tell you why I think the anti-union stance of the college or university at this point and what they're doing with the collective bargaining agreement is going to harm students and therefore the community, what additional advice or legal strategies I might use to protect them from retaliation and possible termination.
I will respond, but I think I'll give the... And by the way, I think you're on the right track, but I'm going to give the members of the panel the first shot at that question.
I think you're okay. The court actually did, I can't remember the name of the case, that cut back on some ridiculously overbroad readings of the notion that, because you're speaking about things at your workplace, that you are not speaking as a citizen on matters of public concern. So it's not that the union president's job as a public employee to make these statements. That's really, I think, the sensible dividing line between the Garcetti, unprotected when you're speaking as an employee. So I think you're okay. What do you all think?
Well, I'm not admitted in New York, so maybe you are.
I mean, if you take Justice Alito at his word, right, then as long as you say, this is a matter that will affect the working conditions of tens of thousands of public sector employees, before you speak, you should be fine. That said, I agree.
Yeah, I think you could get both sides of the court to back you up on that.
Now,
We'll try if necessary.
You obviously directed the question to me in order to put me in what you believe to be a quandary, since you view my job as defending my university from challenges of retaliation. But actually, the bigger part of my job is to counsel my colleagues, both in the Chancellery and out at the campuses. And if they came to me beforehand with that question of, can I fire this guy for doing that, my answer would be no.
I was actually only trying to use your initial question as cover for going further afield than the...
Okay, okay, very good. Next question.
Not really a question, but I just want to offer the suggestion that the current climate that we're facing didn't come from nowhere. That if you go back through the history of the last several decades, that after the New Society and the rise of the New Left in the 60s, the conservative movement, in a very proactive and concerted way, established a series of think tanks, conservative think tanks, that after several decades we're seeing the result of that.
Well, Sophia Lee's book, which Ruben has talked about, is fantastic. It goes way back, further than that. It goes back, well, let's first take it right after the Wagner Act was passed. Within a few years, really, the ideas behind the right-to-work movement started forming and took constitutional form. But let's not forget, the Wagner Act was passed at a moment when the Lochner-era constitutional arguments against regulation writ large were just giving up the ghost, were just being abandoned. So it really goes back. It's the history of the 20th century but yes, you're right. This has been refined and elaborated, and the sort of modes of communication, the words that you use, and our arguments, and the instructing a whole generation of law students through the Federalist Society and judges in making them receptive to these arguments, that has continued to sort of escalate.
Yeah,
I think it shows their long view that the book does, and that's why I think even though the arguments or the cases that we're talking about now are pretty remote in terms of their success, immediately, I mean, I think they'll continue, if it takes another several decades, I think they'll continue working on that. At least that's what the history shows. But I also think it's not an accident that this was a case brought against the California Teachers Association, which happens to be a former client of mine. But in any case, that is an education. It's also a strategy within education that I've talked about in terms of sort of deregulating or privatizing education that I think is part of this as well.
Yeah, the right has been far more effective at mobilizing the masses than the left has, and we have something we could learn from some of their efforts, I think.
Other questions? I have another one. Because I'm learning some of this stuff for the first time today, since I don't normally have to deal with these issues. So I'd like to engage in a little thought experiment. Suppose the law moves in the direction that you were talking about, of the right of exclusive representation disappears, the duty of fair representation disappears. What does the world of labor relations look like?
Well, I think Ruben talked about how employers might not like it because majority rule sets a difficult threshold for getting any union representation at all. If you eliminate exclusivity, you eliminate majority rule. You can have multiple unions, many workplaces that can't make the majority threshold. There could be a critical mass of workers who would claim union representation, and I think that from our perspective, and given the form of collective bargaining that we have, it would be pretty chaotic.
Right, and I think that's why you had many employers, joining with labor in this case to sort of say this is a system that actually works well for us, not just obviously agency, but also exclusive representation, again, with that concomitant duty of fair representation. But I think there have been, as I said, in the private sector, some discussions about members only as a right in before exclusive representation. So that's the Charles Morris, Blue Eagle at Work book. But then even after that, given this future of no exclusive representation, or I guess as the gentleman suggested, this idea that away from collective into this individual, I want my own representative, my own members only union, my own minority union. That, at least has been argued in some recent articles of Catherine Fisk and Ben Sachs about, a right to have that in right-to-work states under the current regime. So again, if that's really the future that they're looking for, then I think, again, a lot of employers would not be, as I said, not very happy with that as a future.
Yeah, I mean, you can just look at the employer response to specialty healthcare, right? The alleged micro units decision, right, about certifying bargaining units in relatively small departments, in department stores or whatever. And then, of course, in the public sector, many of the public sector statutes require large units, right? I mean, that's one of the challenges in the University of Washington organizing drive that somebody talked about earlier, right? By statute, the whole university has to organize together, even though there are separate campuses. So, I guess my concern would be that some states might find it to be too cumbersome to bargain with, smaller units or partial units, and therefore move to curtail public sector bargaining beyond what they've already done.
So I wanted to follow up with Cindy's comment about using the First Amendment in an affirmative way. Not every state in the nation has public sector collective bargaining, and some prohibit it. I'm just wondering what kind of theories could be developed under the First Amendment to do what happened in Canada and arguably under the ILO, to say that collective bargaining in the public sector is a part of a right of association, and that therefore every state should be required to do that, and how to develop a legal theory and legal process to come up with trying to persuade the court to ultimately find that as a constitutional right of association to collectively bargain.
I am pessimistic about getting beyond. I think you can get protection for the formation and participation in associations of workers. That's not really what you're talking about. In Canada, the freedom of association has been injected with this ILO content to give rise to some sort of constitutional right to get a response. They haven't quite gone so far as to say there's a constitutional duty to bargain with employees, but the right to some kind of constructive engagement. I just have a really hard time seeing how we get past the sort of negative First Amendment of not retaliating against people for seeking collective bargaining, and maybe even so far as the bargaining representative has a right to, hey, petition the government. In the public sector, there's a right to petition the government, but I have a hard time seeing how you get past beyond that to the government has to actually give you some kind of answer.
And again, this is one of those tensions that you could really, was possible, I guess, in terms of Friedrichs, as it might have come out in terms of Justice Scalia being uncomfortable about the idea that everything was political, or all bargaining was political because of the implications of that. And so, as we talked about in terms of his other free speech cases. But I think, again, we'll never really know. You can only assume so much from oral argument, and that might have been something that he would have to deal with. But as we've said, they found other ways to deal with these uncomfortable tensions where it was the possibility that employees would get more rights under the First Amendment than they wanted to give.
Yeah, if you put aside the court's willingness to entertain this tension between its public employee speech cases and the union cases, then maybe you come out with the court saying, well, public employees actually have a much more robust right to be disruptive in pursuit of better working conditions. And maybe we have to cut back on Garcia and maybe even Pickering. And maybe we get to a point where public sector workers are protected to a degree in their sort of collective action that would encourage public sector employees to come to the bargaining table more willingly. Employers, right? Thank you. But the court has certainly been willing to entertain that tension, right? And I find it hard to believe that the court is going to retreat from that position.
Hi, my name is Leslie Burke O'Flynn. I'm from Vancouver, Canada, and I've been doing union-side labor relations for some decades now. On the constitutional issue of the right to associate, first of all, I'm not a lawyer, I'm a labor practitioner, but the right of association is embedded in the Charter of Rights and Freedoms, which is part of the Constitution. And we recently, over the last few years, have had a triad of cases that have gone to the Supreme Court of Canada for an interpretation of that right, which, interpreted broadly, has included the right to bargain and the right to strike within that association constitutional right. So I just thought I would say that plainly because it's one of the foundations of our labor relations paradigm in Canada.
We bow in admiration to Canada. Of course, the freedom of association and right to engage in collective bargaining is also part of the fundamental core international labor rights that the ILO recognizes, the U.S., of course, being a founding member and is bound to those principles. But our courts have been unusually resistant to the notion that that tells us to do anything that we haven't already chosen to do domestically. In other words, we think we invented freedom of association with the Wagner Act model with all its limitations, and so you people out there in the rest of the world have no business telling us what the freedom of association means. I think that could change at the margins going forward, depending on how the court, the Ninth Justice, but it has been a long-standing, fairly solid resistance to taking international law on board to influence the content of our domestic law.
I don't see anybody else at the mic. We are 8 minutes early, so...
This is unheard of.
Unless one of the panelists would like to make a closing statement, we'll give you a slightly longer coffee break. Thank you so much for coming.
This ends a podcast from the 43rd Annual Conference of the National Center for the Study of Collective Bargaining in Higher Education and the Professions at Hunter College in New York City.